Welcome, everyone joining us online, and welcome to our esteemed panelists. This is the second session in a 10-session series on the abolition of the death penalty. Towards the Abolition of the Death Penalty is a virtual panel discussion series that tackles the complex question of the death penalty with a view to its abolition in retentionist states, particularly in the contemporary context of the Middle East, in Iran, Saudi Arabia, Afghanistan, Egypt, Syria, and Iraq. The panel series provides in-depth discussions on the death penalty from diverse legal, philosophical, sociological, psychological, and political perspectives. The speakers will address and put into context current instances of the death penalty, exploring the dynamics involved in this criminal sanction. The series creates a dialoguable platform for everyone interested in engaging with the abolitionist discourse to discuss the possibilities and challenges to put an end to the death penalty. The series is offered in a joint partnership between Amnesty International Canada, Carleton University's Youth and Justice Lab, the Human Rights Research and Education Centre at the University of Ottawa, the Canadian International Council, Saskatchewan Branch, the Payvan Society, and the Mardum Foundation. On the occasion of International Women's Day, today's session focuses on women and the abolition of the death penalty. Our session today will consist of 3 panelists that will be followed by a question and answer period. On the occasion of International Women's Day, and to help illustrate the lives of women who face execution and the abhorrent injustices that brought them there, we want to highlight one case. Pakshan Azizi has been sentenced to death on state-sanctioned murder. She is currently a political prisoner in Iran. Pakshan is from the Kurdish majority city of Mahabad and was working with several NGOs on women's issues. In 2014, her work took her to the area where she learned of refugee camps in the Rojava region, where northern Syria converges with Iraq and Turkey. After arranging safe passage with Kurdish authorities, she traveled to the city of Khamishli and then to the UNHR established camps of Nowruz and Al-Hal. The UN calls Al-Hal a blight on the human conscience. Al-Hal is under the aegis of the US-backed Kurdish Syrian Democratic Forces, or SDF. Its population ranges between 45,000 and 75,000 refugees coming from over 50 countries, though most are Syrians and Iraqis displaced by the expansion of ISIS forces. At its height, the caliphate controlled a population of 10 million people across a third of Syria and nearly half of Iraq. Over 90% of the camp's population are women and children. Half of those children are under the age of 12. Pakshan spent nearly 10 years working in these camps and wrote on August 24th, the Ministry of Intelligence agents arbitrarily arrested Pakshan Azizi in Tehran and transferred her to Section 209 of Tehran's Evin prison. Since then, she has spent more than 5 months in solitary confinement and has been subjected to torture. Pakshan Azizi's crime is being a humanitarian aid worker. But simply being Kurdish and a woman takes on a whole other dimension under Iran's system of governance. Pakshan is facing imminent execution despite Amnesty's repeated calls for her release. Amnesty International's Deputy Director for the Middle East and North Africa, Diane El-Tahawi, accuses the Iranian authorities of using the death penalty as a tool of political repression. Quote, to instill fear among the population, Pakshan Azizi was unjustly detained and sentenced to death following an extremely unfair trial in the revolutionary courts. Pakshan Aziz was detained solely for her peaceful human rights and humanitarian activities. She shouldn't be facing imminent execution. She should be released immediately and unconditionally." End quote. Our first speaker for today is Sandra Babcock, a clinical professor of law at Cornell Law School, Cornell University, specializing in international human rights litigation, access to justice, death penalty defense, international gender rights, and the application of international law in U.S. courts. Ms. Babcock, the floor is yours.
Hello, it's wonderful to be here. Thank you so much for having me. I'm, this is such a big topic, and I guess I want to start by recognizing that even having this panel is something that would not have happened as recently as 8 years ago. 8 years ago, my colleagues and I at the Cornell Center on the Death Penalty Worldwide began a research study to try to find out more about women who were sentenced to death around the world. And what we found was just an absolute dearth of data. Nobody was tracking the numbers of women. Nobody was gathering information about the kinds of crimes for which they'd been convicted and sentenced to death. And it was just really a black hole. And as we started to dig deeper, we realized that the cases of women, not surprisingly, were fundamentally different from those of men who were on death row, for a number of different reasons. Number one, we found that the crimes themselves were quite different. Women, when we talk simply about homicide cases, women tend to be convicted and sentenced to death for killing people that they know, intimate partners, sometimes children, sometimes family members, and many times these crimes are directly linked to their experiences of gender-based violence. We found that their pathways to incarceration were deeply gendered, that they had, many of them experienced multiple forms of gender-based violence. And moreover, we found that when it came time for them to be prosecuted in the courts, that the courts were minimizing, dismissing, or ignoring these gendered aspects of women's experiences and what led to the actions for which they had been incarcerated and were now facing the death penalty. We also found, there are many reasons we can explore in the Q&A as to why women's experiences were rendered invisible. Partly, I think in large part, it is that we ourselves, even within the community of human rights activists who are deeply concerned about state-sponsored violence, such as the death penalty, we had certain assumptions about women on death row. There is a prevalent assumption that women are the beneficiaries of gender bias that operates in their favor, this so-called paternalistic bias that treats them as passive and helpless and nonviolent, and that they benefit from that kind of violence in criminal sentencing proceedings. There is some evidence for that. But the evidence that has been gathered, the data that's been gathered, first of all, it's only in a few countries around the world. And secondly, it's mostly in non-capital cases. So when we look at the universe of women who've been sentenced to death, that doesn't explain why they ended up where they are and why they are now facing state-sponsored executions. We turned to the United States because we were able, after we published our first report in 2018, which led to a reckoning in the international abolitionist community about its failure to address gender discrimination as an inherent feature of the death penalty. During the pandemic, we began to focus on women on death row in the US to see if we could do a deeper dive into their cases and find out exactly what was going on, what were some of the common features in their lives, what were their crimes, and how had they been treated during their trials. What we found was that overwhelmingly, women on death row in the United States have been subjected to multiple forms of gender-based violence before the crimes for which they've been convicted. And I say crimes, even though there are women on death row who are innocent, such as Melissa Lucio, who had been convicted of killing her daughter, but within the last few months, a trial judge in Texas concluded that she is actually innocent, even though she spent over a decade on death row, where she remains today. Even those who have committed crimes, who are guilty of a homicide, those crimes are the culmination, in many cases, of decades of gender-based violence that has never been fully addressed, for which women have never received therapy or treatment or protection from the state. So women on death row are victims long before they become perpetrators. We found that 96% of women on death row in the United States had experienced at least one form of gender-based violence, and that the great majority had experienced multiple forms. The most common form of gender-based violence is child sexual abuse, but intimate partner violence is also widespread. So that was the first thing. The second thing we found is that women's crimes are very different and their histories are very different. So unlike in distinguishing them from men, and this is why it's so difficult to compare women to men, because their crimes are very different and they are very different. The great majority of women have never committed any crime at all before the arrest that led to their capital prosecutions. And so what that means, at least in the United States, is that when prosecutors make a decision to seek the death penalty against a woman, they don't have the kind of aggravating evidence that is often available in the cases of men, many more of whom have a criminal record at the time they're arrested and prosecuted for capital murder. So the kind of aggravating evidence that prosecutors would typically rely upon in seeking the death penalty is a criminal record, a record of violent behavior in the past. That is simply absent in the cases of the great majority of women who have been prosecuted for capital murder. So what do they do instead? This brings me to the other feature of women's capital cases that we have found is prevalent to a degree that is truly shocking in the 21st century. They rely on deeply gendered tropes and stereotypes about women's role in society and the defendant's perceived deviation from those roles. So I'll give you a few examples. There was a case of Brenda Andrew, who is on death row in Oklahoma. She's the only woman on death row in Oklahoma. And she had no criminal record at the time of her arrest. She maintained her innocence. She was charged with killing her husband, who was killed by gunshots in the couple's garage, and they were separated at the time. The prosecution at her trial, because there was no forensic evidence linking her to the crime, her co-defendant, her male co-defendant, had exculpated her, had confessed himself to committing the crime, and had said she had nothing to do with it. The prosecutors brought in witness after witness to testify to intimate relationships that she had had, one of which was 20 years before the offense occurred. Not only that, but they brought in witnesses to testify about outfits that she wore, whether they could see her cleavage, how short her skirts were, the material of the outfits that she wore. They also talked about her flirtatious behavior. So she flirted once in the grocery store with a man, and her children were present, and the prosecutors emphasized that she was flirting while her children were present. They called her a hoochie. They called her a slut puppy. And in the closing argument of the guilt phase of trial, the prosecution actually took out multiple pieces of her underwear and held them in front of the jury and said, "This is not the kind of underwear that a grieving widow would wear." Now, to understand the gendered aspect of that presentation, one need only imagine the prosecution holding up a pair of men's boxers and saying that a men's boxer shorts were indicative of the kind of person he was and his guilty conscience. And obviously that is just laughable. It would never happen. And so the way that we perceive and the way that prosecutors present women's sex lives at trial, and this is just one example among many. There's another case in Arizona right now of a woman on death row where prosecutors speculated and invited the jury to speculate as to whether she needed lubricant before she had sex because she had had sex with so many men. There's a case in Ohio where a woman had had intimate relationships. She was white and she'd had intimate relationships with a Black man and a Latinx man. And the prosecution actually argued to the jury that she preferred Black men. So highlighting there is a racialized dynamic to this as well. And of course, women of color experience multiple forms of discrimination. So there are women who have been sentenced to death where prosecutors have said things like, she may be a woman, but she's no lady, something that that resonates with the defeminization of Black women in the United States going back to the time of slavery. So these are the kinds of evidence that we have begun to uncover that indicates that gender bias is widespread to a degree that has never before been recognized. Up until January 21st, 2025, the Supreme Court of the United States had never acknowledged that gender bias exists and that it can have a detrimental impact on the cases of women in criminal courts around the country. But finally, in the case of Brenda Andrew, the one I just mentioned, where the prosecutors displayed her underwear to the jury, the Supreme Court, in this historic decision, held that that evidence was irrelevant and that a lower court needed to assess whether it was so prejudicial that she should be given a new trial. And obviously, we expect and hope that the lower court will find that there is no way that that kind of tactic could be deemed harmless. But the fact that it is 2025 and that is the first time that gender bias has been acknowledged is a testament to the invisibility of gender bias and the normalization of gender bias, which exists to an extent that is still, I think, understudied and underappreciated. So I think I will stop my comments right there. Thank you.
Thank you so much. Those were egregious examples. I can't even believe that a prosecutor brought a woman's underwear into the courts as a form of showing that she's not, the sort of diminishing her behavior or saying, a grieving a widow doesn't behave in this manner to wear this underwear. And I for sure will come back to that during the question and answer period. And just a note to all of the people listening online, you can, in the chat section, include your questions for our panelists, and we will get to them at the end. Our next speaker is Professor Roja Fazayeli, Professor of Law and Islamic Studies at the Irish Centre for Human Rights at the University of Galway. Professor Fazayeli has published widely on the subjects of women's rights in Iran, the relationship between human rights and religion, women religious authorities, and Islamic feminisms. Professor Fazayeli, the floor is yours.
Thank you very much, Samira, for the introduction, and also thank you, Omid, for the initial invite and all the organizers. So very briefly, in the 10 minutes that I have, I'm going to speak a little bit on the Iranian Islamic Penal Code, as well as death penalty and gender in Iran. So according to the Iranian Islamic Penal Code, the following criminal offenses are punishable by the death penalty: premeditated murder, sexual relationship outside marriage, zina, and or sexual intercourse with the same sex. This is considering specific circumstances of the encounter and its repetition. possessing or selling illicit drugs, human trafficking, fraud sometimes is in there as well, robbery, that is if it's repeated 4 times, and after enforcement of had 3 times. And also conviction of ifsad al-fil ars, which is sowing corruption on earth, all subject to had. Furthermore, one of the penalties prescribed for muharebe, waging war against God, is execution, also enforced under had crimes. According to Sharif Bassioni, there are 3 categories of crimes in Islamic law: hudud, qisas, and ta'zir. Hudud is the plural for had, which literally means restraint or prohibition. So had, or the punishment for a crime in the hudud category, is ascertained in accordance with God's right and is prescribed by the Quran or the Sunnah. So prosecution and punishment for crimes of had are obligatory. So the judge therefore has no right to add, alter, or reduce the punishment after it has been decided as hudud. There are 7 crimes which come under hudud: rida, which is apostasy; baghi, transgression. So actually, Pakhshan Azizi, that you highlighted her case, she's basically sentenced to death for baghi, transgression or armed rebellion. Saraqa, which is theft; haraba, which is a highway robbery; zina, adultery; slander; and also sharab al-khamr, drinking of alcohol. So there is no common agreement actually between Islamic jurists regarding which offenses count as hudud. So each of the 4 Sunni schools and the Shia schools rank these crimes differently. For example, according to some schools of law, apostasy and highway robbery are punishable under hudud ordinances, whereas others classify these under ta'zir. And some Shiite sources of emulation, marja' taqlids, for example, Ayatollah Khoei, have actually increased the number of punishable crimes to 18. And this expanded list includes blasphemy, sorcery, and claiming to be the messenger of God. Hudud crimes that are actually punishable by death include some sexual crimes such as adultery, rape, sex with families, zina, maharem, and sodomy. Some cases of muharebe, this is contingent upon the judge's decision. This is basically like war with God. Apostasy, all crimes which are which are punishable under hudud if they are repeated 4 times. Then the next is qisas, or law of retribution, and this is defined as crime that combine what common law considers crime against a person and torts of the same type. So the word qisas means equivalence, and hence the punishment for it should be equal to the crime committed. In other words, an eye for an eye, a limb for a limb, and a life for a life. It is important not to equate the term to retaliation or revenge. There is actually no Quranic specification regarding qisas. Instead, legal doctrine and judicial decisions and in recent time, legislation have shaped the meaning and content of such crime. So again, going back to Bassioni, he says murder, voluntary homicide, involuntary homicide, or manslaughter, intentional crimes against a person, and unintentional crimes against a person may all fall under qisas category. So the death penalty, however, is only provided for in murder cases, and it is understood to be applied only when killing is unjust and murder was intentional. So at the first glance, capital punishment under qisas is equal between men and women, but qisas is actually riddled with exceptions and exemptions, particularly when the victim is female or one who commits the murder is also a family member of the victim. So, for example, under some interpretations of Islamic law, qisas would not be applicable to cases in which a father or parental grandfather kills his own child or grandchild. This is based on hadith or many ahadith of the Shia imams. Some Sunni schools of law believe that mothers and grandmothers are also completely exempt from qisas for killing their children or grandchildren. In terms of when it comes to the father or grandfather for killing of their children, it's not that there is absolutely no penalty. They do get a prison sentence, and there's been some debates in the last few years, particularly of the justness of this. Not that some activists have been talking about this, not in terms of they should get qisas, but in terms of the sentences are not representative of the crime itself. So it could be, for example, 3 years in prison. Imprisonment. Furthermore, according to qisas, if the murderer is a member of the family apart from the father or grandfather, or if the murderer is hired on behalf of the woman's family, as in the case of honor killings, the victim's heirs, awliya dam, could agree to waive the right to demand qisas and save the murderer from the death penalty. So now we come to ta'zir, which is defined as discretionary punishment imposed by a judge for offenses not covered by hudud or qisas. The penalty for ta'zir ranges from fines, imprisonments, physical punishment, and other compensatory and punitive damages. And the types of crimes under ta'zir can be very broad, so penalties are also very broad. The punishments under ta'zir range from admonition to fines, seizure of property to the death penalty. So most schools of Islamic law state that the death penalty cannot be imposed under ta'zir unless there are extraordinary circumstances such as spying for the enemy or spreading heresies or sorcery. It's important to note, however, that all sentences under ta'zir can be changed by judicial authorities. As Ziba Mir Hosseini states, under the category of ta'zir, Islamic states have introduced new punishments with no precedence in classical fiqh in order to impose their notions of Islamic morality. For example, the majority of executions in Saudi Arabia and Iran under ta'zir are related to drug offenses. Iran also tries apostasy under ta'zir crimes and punishes these offenses by execution. So now I'm going to talk a little bit around kind of gender, particularly women and death penalty in Iran. There is actually a recent report which has come out by Iran Human Rights titled Women and the Death Penalty in Iran. They basically state that between 2010 and 2024, at least 241 women were executed. And in 2024 alone, 31 women were executed in Iran. However, given the lack of reliable data, these numbers may be higher. Only 26% of women's executions are apparently officially announced. According to the same report, there are also an unknown number of women who remain on the death row. So this includes currently Kurdish activist Verishe Moradi and Pakhshan Azizi, who you've mentioned already, both of whom remain at imminent risk of execution. There are very few studies which have been conducted on gendered perspective of the death penalty in Iran. So one is the above mentioned report. Another is an academic dissertation, which actually I supervise, written by Iranian journalist and researcher Mariam Foumani, and also for noting is a recent publication in 2022 by Sanaz Alasti. All of these studies existing socio-legal and intersectional inequalities, discriminatory laws which trap women in cycles of violence and perpetuate the suffering of women on the death row. I'm going to finish very quickly. I think I'm out of time. Was that beep for me? Or
yeah. No, I don't think it was for you. It was for someone.
No, it wasn't for me. Okay, sorry. I thought that meant your time is up. So in briefly making mention of some of these legal discrimination, I also want to note that according to Iran Human Rights, women from marginalized ethnic minority regions, such as Sistan and Baluchistan, Azerbaijan, and Kurdistan, are disproportionately represented on the death row. And this underscores the intersection of systemic discrimination, poverty, and judicial bias in Iran. I also want to give an example where there's case of Rahele. Unfortunately, I don't have her surname, that actually Mariam Foumani writes about in her book, The Forgotten Women, Voices from Behind Bars in Iran. Iranian woman who was executed for killing her husband. And there was, through her stories, when a lot of these stories go unheard, but this was actually published both in the book and on a number of other kind of online journals. And it shows that she was a victim of domestic violence. But another thing to highlight there as well, Rahele was also Azerbaijani, and her language was Turkish. She actually didn't speak any Persian. When they brought her to the court, she wasn't given an interpreter. And that again shows kind of the intersectional discrimination within the judicial system in Iran, just as an example. So upwards of 70% of women sentenced to death for murder in Iran are charged for murdering their male partners. Yet in Iran, the context of domestic abuse and coercive control is not often acknowledged. In the legal system, women's testimonies are worth half of men's. The law fails to recognize domestic violence or marital rape. As a result, many of these women are left without an appeal to self-defense in court and instead face qisas, where the victim's family are given the responsibility of deciding between an act of forgiveness and the receipt of blood money or execution. To note some other laws which discriminate against women, these include laws pertaining to divorce, custody and guardianship of children, age of maturity, age of criminal responsibility, and inheritance laws. So once in prison, many women are abandoned by their families. They also often lack access to legal counsel or resources to navigate the judicial system and defend themselves. Additionally, they're often deprived of emotional support as they face inhumane prison conditions. Poverty and illiteracy are additional compounding factors in many cases, particularly among ethnic minority women. Many Iranian women, therefore, remain trapped between abusive marriages and abusive legal system, and a death penalty is too often the result. Thank you for your time, and sorry if I took more than 10 minutes.
That's no problem at all. Thank you so much for your presentation. It's interesting the similarities you see between women in the prison system in America and women in Iran, despite the very different legal systems that each country has. And I'm hoping to come to that in the question and answer period. Our third speaker for today is Dr. Lucy Harry, who's a research associate at the Death Penalty Research Unit at the Center for Criminology at the University of Oxford, where she completed her postdoctoral, doctoral, and master's studies. Her research focuses on cases of women sentenced to death for drug trafficking in Malaysia. For her postdoc, she worked with Professor Carolyn Hoyle on drug policy in Southeast Asia, as well as mapping cases of migrant workers sentenced to death in the Middle East, with a particular interest in cases involving female migrant domestic workers. Dr. Lucy Harry, the floor is yours.
Thank you so much for the opportunity to present. Today, I'm going to talk about my research on women who were sentenced to death for drug trafficking in Malaysia. So first of all, why focus on Malaysia? Well, the World Coalition Against the Death Penalty published a report in 2023 on mapping of women on death row worldwide. And the data at the time showed that Malaysia had the highest number of women on death row, with 129 women under sentence of death in that jurisdiction. The data was from 2021, and it should be noted that this is of jurisdictions where data are available. And as the other speakers have spoken to, that can be a challenge. Another important feature of the Malaysian death penalty is that, according to 2019 data from Amnesty International, a higher proportion of women are sentenced to death for drug trafficking, and a higher proportion of women on death row are foreign nationals as compared to the male death row population. And this accords with what I found in my own research, where 90% of the women in my sample were foreign national. In Malaysia, the death penalty is carried out by hanging, and it's currently used mainly for homicide, drug trafficking, and firearm offences. And the last execution occurred in 2017. Some limited reforms to the mandatory death sentence for drugs occurred in 2017, but it continued to operate mandatorily in practice. In 2018, the government announced plans to abolish the death penalty, but after political upheaval and some reneging on this promise, the mandatory death penalty was abolished in April 2023. Following this, from November of that year, Malaysia undertook a sentencing review process for the over 1,000 individuals on death row. By October of last year, this process was complete and 860 applications were allowed, and the death sentences were substituted with imprisonment with whipping. Notably, women aren't eligible for that, though. All of those cases where the death penalty was maintained involved aggravated murders, and so none of the death sentences for drug trafficking were upheld, and thus the 100 or so women on death row would all have been resentenced. So even though there are currently no women on death row for drug trafficking in Malaysia, this research is still important, not least because these women are now likely facing long terms of imprisonment, which are unduly harsh penalties for non-violent drug offences, but also because there are women on death row worldwide for drug offences. So 34 countries around the world retain the death sentence for drugs, which is in contravention of international law, as it does not meet the stipulation for most serious offences under the ICCPR. Data are hard to come by, but the World Coalition reports that there are women under sentence of death for drug offences in China, Indonesia, Iran, Pakistan, Singapore, Sri Lanka, Thailand, UAE, and Vietnam. And more generally, in the last 20 years, the global female prison population has increased by 50%, much of it attributable to low-level drug-related offences. So in terms of my method, my research focused specifically on women sentenced to death for drug trafficking in this jurisdiction. And I conducted fieldwork in KL in 2020, which included interviews with those involved in the women's cases. So lawyers, judges, prosecutors, police, NGO activists, consular officials, because the majority of the women were foreign nationals, and religious counsellors who would work in the prisons. And I also conducted a review of all of the available court judgments and also a review of media articles related to women's cases. And I found 146 cases of women who'd been sentenced to death for drug trafficking between 1983 and 2019. And 1983 is when the death penalty became a mandatory sentence for drugs in that jurisdiction. It should be noted that due to ethical and access issues, I did not attempt to interview any of the women on death row themselves. So what did I find? Well, from analysing my data and the circumstances of the women's cases, I found the concept that helped me to make sense of these findings is what is known as the feminization of migration. So this is a trend that's emerged worldwide since the 1980s, particularly in the global south. Whereas historically, economic migration was portrayed as a male process, since the dawn of globalization and industrialization, we've seen increased numbers of women migrating for work and as the breadwinner in order to send remittances back to their families at home. And I found that many of the foreign national women on death row in Malaysia tended to be from other countries in the global south. So the most common nationalities were China, Indonesia, Iran, Thailand, and the Philippines. And many of the women were migrant workers. So they were working as domestic workers or traveling for other forms of precarious gendered labor in the region. For example, they were traveling to work in massage parlors or in factories, and they claimed that they were duped by their recruiter, who asked them to carry a bag to their new employer, or who offered them a new suitcase to put their possessions in, which later turned out to have drugs concealed within it. Many of the women in my sample were engaged in precarious work prior to being arrested and or were traveling to work overseas in a precarious sector. And so I conceptualized drug courier work as an extension of this gendered precarious labor. Many others claimed that they were working as what is known in the literature as cross-border informal traders, where they were paid to courier items in their personal baggage across borders in order to avoid customs duties. This is an established practice, often occurs in the global south, and is dominated by women. And so they claimed that they were paid to courier items such as clothing and electronics, and they were duped by their supplier, who concealed drugs in the lining of their bag. Many of the women stated in their legal defenses that they were engaging in couriering for gendered economic reasons. For example, they were divorced, a single mother, or they needed to pay for relatives and medical bills. And so they were paid to courier something across a border, or they were looking for a job overseas, and they were duped into carrying drugs in the course of this arrangement. So overall, it seems that drug trafficking syndicates are capitalizing and exploiting this transnational flow of female labor and duping female economic migrants into carrying drugs across borders. Just to give you a quote from one of the lawyers I interviewed, he talks about described the case of one of the women he was representing who was on death row. She was a foreign national, and he says she worked in a factory and she was divorced with 2 children. She was given a work opportunity to come to Malaysia to work in a massage parlor. She'd never traveled before. She didn't even own a suitcase. She turned up at the place where she'd collect her ticket with just plastic carrier bags with clothes in them. The person who offered her a job as a masseuse gave her a bag to take with her to Malaysia. And once she arrived in Malaysia, she was supposed to drop the bag off at a particular address to a particular person. She had all of this information in a text message. So she accepted the bag, put her clothes in it, and traveled to Malaysia. When she arrived, the X-ray showed something suspicious in the bag, and drugs were found in the lining. And unfortunately, this story is all too common. I also found from my research that the feminization of migration coincided with the securitization of migration, with drug trafficking being framed as an external threat to the Malaysian nation, warranting the harshest of sentences, with the border becoming a focal point for the policing of drugs. The majority of the women in my sample had been arrested at the airport. And indeed, from my interviews, I was told that there were particular suspect nationalities who were profiled and surveyed at the border, as it was suspected that they were drug traffickers. And often these stereotypes are gendered and racialized. For example, one lawyer told me, there's a profile of a travel-savvy Chinese woman of perhaps no known sources of income, who then is a professional drug mule, and she gets away with it because she's good-looking, she's attractive, she dresses well, and she looks professional. And this connects to other academic research on women's mobility being policed at the border, often as part of anti-human trafficking measures, as well as other work that's been done on the surveillance of migrant domestic workers at the border and also at their places of work. And so this is part of the broader trend and framing of drug trafficking as a threat from an external foreign other who is already marginalized by their economic and immigration statuses. So what are the implications of this case study for wider death penalty abolition work? Well, first, I found that economic precarity is less visible to judges, and therefore women's defenses were routinely dismissed, with comments such as, "We're of the considered view that it is very unlikely that the respondent, who is a diploma holder, could have placed herself in a situation where she could be exploited to commit a crime." Another judge said in a different case, "The background of the accused revealed that she was quite capable of taking care of herself. She had a high school education, she understands and speaks simple English." And others dismissed their cases with reference to the women being well-traveled or ladies of the world. Not to mention that these are very gendered statements, but also all of these descriptions are compatible with someone who is economically precarious and traveling overseas for work. So I think it's important to draw attention to the plight of economically precarious women in the context of capital drugs cases and mitigation. Second, I think this case study is particularly relevant for jurisdictions where the death penalty is mandatory or acts in a mandatory fashion. While there's little work on gender and the mandatory death penalty, we can turn to the existing literature on the impact of mandatory minimum sentences for drug offences in the US context. This work has shown that mandatory minimum sentences for drug offences, part of the US's war on drug, starting from the 1980s onwards, have a disproportionate impact on women of colour from low socioeconomic backgrounds and also their children. Third, drawing attention to these stories is important from a public opinion perspective. So Roger Hood conducted a study on public opinion on the death penalty in Malaysia in 2013. And participants were given different scenario cases to assess. And when they were presented with the case of a young Malaysian woman caught at the airport with 100 grams of heroin hidden within her suitcase, only 9% of people thought that the death penalty was an appropriate sentence. And 80% of those who had previously stated they were in favor of the mandatory death penalty did not impose it in this case. And finally, this case study speaks to the arbitrariness of the death penalty. We know from plenty of research that those who are sentenced to death and executed are much more likely to be among the least powerful of all those who are convicted of capital crimes. And when the mandatory death penalty for drug trafficking was abolished in India, with the case of India Harm Reduction Network and the Union of India, so this was a 2012 case, the petitioner noted that it is poor people, whether they are drug users or carriers, who are subjected to harsh penalties and bear the brunt of criminalization. The imposition of a mandatory death sentence, a barbaric and irreversible punishment, disproportionately affects the poor and vulnerable. And here, with the Malaysian case study, we see the arbitrariness and discrimination occurring at the intersections of gender, citizenship, and socioeconomic status. And fundamentally, a punishment that extinguishes a life can never be justified within a system with high levels of discrimination. And I'll end my comments there.
Thank you so much, Dr. Harry. It's interesting because I know that in Iran, a lot of I think there were 900 plus executions in 2024. The majority of them were for drug offenses. It's interesting there how the two sort of overlap in that way, because I believe Iranians who are migrating don't need visas. Malaysia is a country that Iranians don't need visas to go to. While people start to put in their questions into the chat, I have a question I'd like to start with for Professor Babcock. In what way, because you were talking about the courts dismissing the gendered aspects of women's cases, what do you think it will take to make the court system acknowledge and put into practice to recognize the gendered aspects of the backgrounds of the injustices that these women have faced? What will it take?
Well, I think it's going to take a multi-pronged approach, right? So obviously gender bias is part of our culture. We live in a patriarchal society. Judges and jurors are part of that patriarchal society. And so are lawyers, so are defense lawyers. So I think the first thing that needs to happen, as with any kind of cultural change, is we need to share information and knowledge about gender bias, and what is gender bias language and why is it so harmful. We need to educate lawyers, defense teams about how to challenge prosecutors' attempts to use gender stereotypes in women's capital trials. And they need to educate judges about why those stereotypes are so harmful. In most cases, lawyers aren't even objecting when this evidence is introduced. So defense lawyers themselves have to, first and foremost, become educated and be on the front lines of this educational effort. We also need a lot more research. There's a real dearth of research in this area. And so we are now, my colleagues and I are doing an in-depth study with an interdisciplinary team to try to generate the first scholarship that actually measures the prevalence of gender bias and the types of gender bias that are introduced in women's cases. And that will be, the first national study to make that, to publish that data. So, I think there are a number of different things that need to take place, and I think it's going to take a while. But I'm hoping that this Supreme Court decision will help at least sensitize people that this is deeply problematic, and that gender bias needs to be treated the same way that we treat racial bias in court proceedings. And courts have come a long way in acknowledging, what we call dog whistles. So language and images that tend to be used in the cases of Black people facing the death penalty, like animal imagery, have increasingly been called out by the courts. And there are similar things in women's cases that are clear indicators that gender bias is at play, and the courts need to get to that point where they recognize them instantly and take efforts to, or make efforts to prevent those from being introduced or considered by the jury.
Thank you so much. Professor Fazayeli, I just want to ask you, as you were listening to Professor Babcock talk about gender-based violence being most of the reason why a lot of women are in the prison system or facing death penalty, and then also that it's mostly minority women who are facing you. What sort of similarities did you see between the women on death row in Iran and in America?
I think, Samira, you kind of highlighted this, just the fact that there are a lot of similarities. And part of it, as Sandra was speaking now, comes from this patriarchal institutional, or how kind of the judiciary is organized. For example, in Iran as well, it's the interpretations of Shia Islamic law as well, and the fact that so many of judges are men and trained within this legal system that's highly patriarchal and also religious in a way that religion then is used as means of discrimination, particularly against women. But again, as Sandra was speaking, so the example that I gave, and thanks to Hossein, who gave me the name of surname of Rahel Zamani, who was executed, I think, in 2008. And in her case, for example, she was trapped in this marriage that was highly violent. So she, in the stories that Mariam Foumani has narrated, kind of from prison, from when she was there with Rahele, she basically explained how her husband used to beat her and how violent it was, from throwing her down the stairs, pulling her hair, rejecting her, saying, "I don't want you, you're ugly." Once she was beaten so badly that she ended up in hospital for a number of days. When she came back, she found someone who spoke, who would translate for her and spoke for her in the court, or translated for her. And she went to ask for a divorce. And apparently the judge said, "Well, he's only beaten you once, so go back and put up with it." And again, I think these are these gendered perception that these women in some ways either should take it, or they deserve it because of the way they're acting, or as a mother, as a sister, as a daughter, you should act in a certain way within the realms of the house. So yeah, definitely a lot of similarities there, and yeah, we can talk more as questions come in as well.
Do you find that there's a precarity in Iran to the sort of laws? It almost seems like there is no rhyme or reason. It really depends on what judge you sort of the case comes before. Because I recall you mentioning sorcery and things of this nature that there are laws against, and it was hard for me not to laugh at that point. But it feels very precarious, the law there. As you said, it's not even Quran based. So how does one even defend themselves against something like waging war against God?
Yeah, no, exactly. Like these are certain charges that are just ridiculous. And I see Omid here is asking if reason can play. I actually didn't read the whole thing in any of this, because reason within Islamic law could play a role where it could be the discretion of the judge However, as you know, in the 1980s, between 1980 and 1988, a lot of political prisoners were executed in Iran, and part of these was, they were executed as they were مفسد فلحرز. Sorry, my daughter is in the kitchen here. I was hiding, so if you hear click clacking, that's her in the background, being cropped on earth or waging war against God. Like a lot of these come to the discretion of the judge, but again, the judges, the judges do use religion as a way of basically saying that these charges are reasonable in some ways. But yeah, absolutely. In many ways, the discretion of the judge and the sentence itself, they cause a lot of questions. Like, for example, the two cases, particularly Pakshan's case, Pakshan Aziz's case, like there's so many activists working on this, saying Pakshan is a human rights activist, Pakshan is a human rights defender, and whereas she's charged with Baghi, which is with armed rebellion. So again, this comes back to, how is she charged? Which judge was presiding over her case? And also, there is also the context and the history of her case as well, which we don't really have time to go into at the moment.
Thank you so much. Before I go to the questions that are in the chat, Dr. Harry, you mentioned sort of the feminization of migration, whereas we used to think, it was men who would sort of go out and into other countries, and you talked about the number of foreign nationals on death row. And these women being duped as mules, as drug runners. What did you find about the court system and the women's defenses? Did the court system in any way take these defenses into consideration? And if not, why not?
Yeah, thank you so much for the question. So the death penalty was either operating in a mandatorily or in a mandatory fashion, despite some reforms to the legislation. So oftentimes there wasn't necessarily an opportunity to consider their defenses, but when there was, they weren't believed. So it was seen that they were improbable, these stories were made up, and comments were made, as we see in other jurisdictions, which the other speakers have highlighted, about the women, about the fact that, you speak English, you've traveled abroad before, you're not naive. Why would you have been duped into smuggling drugs? And sort of value-based comments were made about how their defense was improbable, and that there's sort of this stereotype, I guess, amongst the judiciary of this sort of vulnerable female naive dupe who is a likely victim in these scenarios, yet the women presented before them didn't fit those stereotypes. So what I was hoping to show with my research is that economic precarity sort of presents itself in a different fashion from, abject poverty, and that there are gendered reasons for why women might have become embroiled in drug trafficking, and that these stereotypes that the judiciary held were inaccurate and also paternalistic and patriarchal.
Thank you so much. I'll go to the first question here. It's from an anonymous attendee. And I think I'll put this to you, Professor Babcock. The question is, how can the legal system better account for the mental state and emotional experiences of women in violent crime cases?
It's a really big question. And so I'll provide just two suggestions. Of course, expert testimony can be very helpful. And when I say expert, I don't just mean people with degrees after their names. So in the cases of women who have experienced violent relationships, there is a long-held stereotype that is simply untrue, that if the relationship were truly violent, then she would just leave. And that is a very, I mean, it is an assumption that is belied by the experiences of many women and experts who have shown that the risk of a woman being killed in an intimate partner relationship is highest at the point where she leaves. And also if women have children, for example, it's very, very difficult to leave a violent relationship in some circumstances where their partners may get custody of their children who are also at risk of violence. Okay, so who can educate the court about those dynamics? Obviously, an expert in trauma and in the dynamics of intimate partner violence can educate the courts, but also other survivors can educate the courts. And we need to be incorporating, I think, more of the voices of women who have lived through these experiences as lay experts. So that's one way I think that courts can take these experiences into account. There are many, many experts on the impact, the long-term psychological impact of trauma. But the other problem is that the legal system was developed by men and for men, right? So when we look at the self-defense, and many feminist scholars have commented on this, the self-defense laws are a reasonable person standard, right? So you have to generally be in imminent fear of, of bodily injury that could result in a fatality in order to use lethal force in self-defense. And in the cases of many women, that sense of imminent bodily harm is one that is inherent in this relationship. And they may only be able to take action to defend themselves at a moment at which the defendant is incapacitated, like when they're asleep, right? There have been a number of famous cases about that. And many times women lose their self-defense arguments because the law was simply not developed with their circumstances in mind. So changing the law.
Sorry to interrupt you. I remember that film, The Burning Bed.
Yeah, right. That's a famous one.
Yeah, which was I think based on that. So the husband was incapacitated at the time, so it was saying that she wasn't at imminent risk of death.
Right, exactly.
Yeah. Oops, I muted myself. I think this question is best for Professor Fazayeli. Again, this from an anonymous attendee, does the Shia and Sunni Muslim Sharia laws on how to deal with violent crimes clash at times, or are there no differences when it comes to judging?
It's a good question, but it's a difficult one to answer as well, because there's so many different interpretations of Islamic law. So, within Sunni Islam, there are different schools of fiqh, jurisprudence, similarly within Shia Islam. But one difference, I suppose, at least when it comes to Shia Islam and the Shia interpreted Islam, for example, in Iran, where the state is also involved, is that sometimes within the Shia legal system, there is more weight given to the role of the state and also to the supreme religious authority or the marja, and in decision-making processes. So in that way, the state may have more influence in deciding whether the death penalty is applied or whether the family is entitled, like in terms of qisas, for example, whether the family is entitled to forgiveness. But also, like when it comes to crimes that are defined under Tazir, there is a lot of discrepancies between different kind of judicial systems, being Sunni or Shia. So I hope that answers it somewhat.
Yeah, I think it's a difficult, as you said, it's a difficult question to answer because there are various schools of law within both Shia Islam and Sunni Islam. Dr. Harry, in terms of the court system, the legal system in Malaysia, is there any sort of movement among lawyers to have some sort of reform or anything?
I'm not sure if I know the right answer to that question. I think so. There are lots of activists, lawyers who are involved in the death penalty abolition movement and look at how it intersects with gender. But one comment that I have, which is sort of related, is I think it's also not just about the court system. I think it's also about the policing of crimes that lead to death sentences. And I find in my research that the policing is focused on particular populations and at the airport. And so gender also comes into play before people even get to the courtroom. And particular people are seen as suspects for crimes that carry capital sentences. So obviously the court is a very important part of it, but even prior to that, gender bias plays in even before the case is heard.
I have another question that I think I'd like to put to each and every one of you. The question is, what can ordinary women do to help the cause of abolition within and outside retentionist countries? Ordinary women. How are we going to define that?
Well, I don't know who is an ordinary woman, but I will say that I think that feminists, at least in the United States, and I think this is true to a certain extent in many other countries, that the feminist movement has not always been an ally of the abolitionist movement, the death penalty abolitionist movement, and has instead been in favor, in some instances, of extremely punitive punishments, especially for crimes that are related to gender. And I think that the mainstream feminist movement, and there are many feminists, and particularly feminists of color, Black women in the United States, who have long been sort of championing and recognizing the links between gender oppression, racism, and the dysfunctional criminal legal system and over incarceration of people in the United States. But the mainstream feminist movement, and that has been calling for many years, has really been struggling against impunity for crimes committed against women, has, I think, struggled a bit to recognize that that we have common cause here, that when we are struggling to illuminate the ways in which women are made into perpetrators, into these one-dimensional beings who are dehumanized and in some cases defeminized, that those experiences are intrinsically linked to the kinds of gender oppression that the feminist movement has long been battling. Just to give you one example, reproductive freedom, right? So reproductive rights are under assault in the United States in a way that they haven't been in decades. And what we see in some cases is that women on death row, many of them were in child marriages. Many of them had pregnancies that resulted from rape. Many of them who sought abortions were those decisions were highlighted in trial testimony in their capital cases. So women's reproductive choices or their lack of reproductive choices have not only had an impact on their pathways to incarceration, but then sometimes come in and are used against them in court. So there are, and now with the increasing criminalization of women's reproductive freedom and choices to seek abortions, I think we're going to see more and more this this demonization of women who try to control the number and spacing of their children, which is, of course, an international human right. And, you know, that might present an opportunity in this really dark time that we're living in to find common cause.
Dr. Harry or Professor Fawzia, which of you would you like me to repeat the question?
I can offer just a more kind of on the ground for political way of getting involved, knowing Amnesty is one of the organizers of this conference. So it's really important to be, I think, to become active in grassroots activism as well. So for example, I keep giving Parshon Azizi as an example, given that she is at imminent risk of the death penalty. So one of the things, for example, we are doing in Ireland is writing to our parliament members and asking them to put pressure on the Irish state to any dealings that they're doing with Iran to bring up these specific questions. And given that she is a woman, I think that women's involvement in this as well, that kind of what Sandra said, the common cause is a really big way of encouraging people to get involved in these kind of activism, and the stories, kind of knowing the stories of these women and forming some sort of emotional relationship to it as well at the grassroots level, I think could be very influential. And the pressure is important. I think the political pressure as well is really important in halting the executions and changing the sentences as well.
Yeah, and
Very,
yeah, I just have a brief comment, which is I think it's important to bring attention to these cases and the women's stories and the circumstances around their criminalization, because research has shown that support for the death penalty reduces when people are presented with cases of women who are on death row and when they see the circumstances and the way that gender plays into these cases. So I think that that can be helpful in countries that still retain the death sentence.
Our next question, I think this may be from a lawyer. It's from Ashaf Rawan, who says, thanks for the great session. My question is how lawyers can do more to reform these death sentences or gender bias legal discrimination. Professor Babcock, would you like to start with that?
Yeah, I think it's a great question. So there are a lot of things, obviously, in individual cases, there's a lot you can do. But in a more systemic way, I think working with local bar associations, getting bar associations to take a position on the death penalty and to support abolition of the death penalty, even getting bar associations to sponsor studies of the application of the death penalty, because as Dr. Harry pointed out, once people have information about who it is that's actually on death row and the circumstances of their lives and that led to their incarceration, the less likely they are to support the death penalty. So putting a human face on the death penalty is vital. In terms of gender bias, I think that educating the bar, and because in most countries the bar is male dominated, men have to play a really active role in educating other men about gender bias and why it is so damning and why it is so inappropriate in a courtroom, and why we have to really police our own internal biases, because we all have them, in representing women and defending them and explaining their actions. So I think, first knowing ourselves and being aware that we all have these implicit biases and how can we overcome them. And then second, working to educate other people within the legal system and trying to marshal powerful allies in that fight.
I just have a quick question before we move on to others answering this question. And pardon my ignorance, but in the United States, Professor Babcock, do you have rape shield laws? Like in Canada, we have what are called rape shield laws, where you're not even permitted to bring up a person's prior sexual behavior as part of a sexual assault case. Do you have such a thing in the US?
We do. Our criminal laws are state by state, so each state is responsible for administering the criminal law. And so and I don't know, obviously what each state's penal code provides, but we do generally have those laws. And it's a good idea if, you've just kind of sparked an idea, which is to compare those kinds of restrictions when they're applied to the cases of women who present as victims of crimes and those who are accused of crimes, and to see if there are differences in the extent to which prosecutors or defense attorneys are getting into women's past intimate relationships. I don't know if that's what you were getting at or not.
Yes, it was, because I just keep thinking of that image of presenting a woman's underwear in the court, just keeps coming up, so abhorrent. Professor Fazayali, would you like me to read the question again?
No, I have the questions here. Thank you.
Oh,
Thank
you
so
do? Okay.
Amira, yeah, I can open them. But I suppose we have Hussein here as well, who has been doing this work in Iran, and I can just give examples. I'm not a lawyer myself. That in terms of working on the death sentences, I know lawyers in Iran, particularly those who do pro bono work, are really extremely influential in trying to get the public to know about the cases and changing the public opinion generally about the use of death penalty, and also in cases where there is blood money involved, or there is a way of trying to, because often the blood money is quite high. So for those of you who don't kind of know what the blood money is so when a person is killed, and the family of the person who's killed wants to ask for the execution of that person for qisas, there is also a need to pay the blood money it could be that the family asks for the blood money and forgives, basically. And often it's more nuanced than this, because also if the murderer is male, in order for them to be qisas, their blood money is also, or some of it needs to be paid. So it becomes quite complicated. But I do know that in Iran, that lawyers play a big part both in trying to get forgiveness from the family of the person who's been murdered, and also in trying to accumulate the amount of blood money, which is often for women who are kind of at risk of execution, and there is a possibility of forgiveness by the family of the person that's been murdered. They come from very disadvantaged socioeconomic backgrounds, so they cannot afford the blood money. So those are just some examples that I can give from within Iran. But again, you do have Hussein here, who has been doing this as in Iran for many, many years.
I should note also that the blood money for women is half of
the blood money for women is half, yes.
For men. Dr. Harry, have you come across any of this in your research on sort of what lawyers can do or are doing in Malaysia?
Yeah, I mean, Malaysia is an excellent example of reforms to the death penalty occurring as a result of the tireless efforts of human rights lawyers there. So I'd encourage people to look up organizations such as ADPAN, Amnesty International Malaysia, and human rights lawyers there were at the forefront of the changes to the mandatory death penalty. So yeah, that's an excellent example or success story.
That's great. Thank you. We have a question from Bahar Amir Hosseini, who I believe is a colleague of yours, Professor Babcock. Bahar says, this is such a great panel, and I thank the presenters and organizers for this. This work is hard and uphill. What do the panelists do to be resilient in the face of so much repression? How do you hold on to hope? A little bit of hope.
I will answer in a second, because I want to actually pull up an email that I got from a client who's a woman in prison the other day, because I asked her the same question. I taught a class to my students on finding hope and joy in human rights work. And I want to read this to you, but I have to pull it up. So if someone else could go first, that would be great.
Dr. Harry or Professor Fazayeli, what's giving you hope right now as you sort of in your research or in the work that you do?
It's a really difficult question, I have to say, because we are at a time where there is so much toxic masculinity, and when you're working on human rights and gender, doesn't matter within which context. You do feel at times hopeless, but I have to say, for me, is a very at a very personal level, is the next generation. It's it's looking at my daughter and her friends, and looking at the next generation of women and men, where they take gender equality very seriously, and they implement it in their day-to-day lives. So that gives me hope that there is a counter to this toxic masculinity that's taking the world over in many senses.
Doctor.
Sorry. I think for me, being part of like a community of brilliant like feminist scholars and academics, and also kind of witnessing what's been described as sort of a new dynamic of states moving towards abolition of the death penalty, I think that gives me hope as well.
Professor Babcock, have you had a chance to bring?
Yes, I have. And so this is like my clients give me hope, because even clients that I have who are on death row, and who've been on death row for years, they have such incredible resilience and strength. And so I feel like if they're able to find that, given where they are, then I have no excuse, right? So I'm going to read you something. This is from Juanetta Harris. She is incarcerated in Texas right now. She actually is serving a life sentence. She is a brilliant writer. She's a journalist. And so I pose this question to her, like, how do you find hope? And she says, from behind these walls, I've learned that hope isn't just a feeling. It's a practice, a daily choice, as deliberate as the sunrise. When the news brings stories of division and political turmoil, I remind myself that throughout history, it's often in the darkest moments that human resilience shines brightest. In my confined space, I've discovered an unexpected truth. Joy doesn't require freedom of movement, only freedom of mind. Every letter I receive, every word I write, every conversation with my neighbors becomes a brick in building something larger than myself. Our strength isn't measured by our circumstances, but by our capacity to find meaning within them. When I hear the late night conversations of very young women sharing their stories, their dreams, their unwavering determination to create change despite their circumstances, I'm reminded that hope is contagious. Even here, especially here, we are proof that the human spirit can transform pain into purpose, constraints into creativity, and despair into determination. This is why I write, to remind both myself and others that resilience isn't just about surviving difficult times, it's about reimagining what's possible within them.
Wow, that was beautiful. Wow. What a beautiful email. That's from Ibrahim Musa. What a beautiful email, Professor Babcock. I want to put a question to Dr. Harry and Professor Fazayel, because we think of this sort of academe and working within academia, how do you make your research accessible to the general public in order to have people sort of move on that research, to move from sort of theoretical into practice?
I don't know, Lucy, would you like to go first?
Sure, yeah, I can. I'm a research associate at the Death Penalty Research Unit at the University of Oxford, which is where I did my academic training. And Professor Carolyn Hoyle, who is the director of that centre, works very closely with lawyers and organisations, most notably the Death Penalty Project, which is an NGO based in London, who represent people on death row all over the world. And so a lot of Professor Hoyle's work is working in collaboration with them to do research that can be used directly in both their advocacy work and also in their cases. So the Death Penalty Research Unit is sort of a bridge between academic work on the death penalty, but also being able to action it in moving towards abolition in a number of retentionist states.
So for me, like my research broadly is on gender, Islam, and human rights. And right now, we have a big project on Muslim women's access to justice, and within certain European contexts. And I have to say, we've talked a lot about methodology, and for us, really, the practice and the people inform our research. So rather than having the theory and going to the field, we are going to the field in order for for us to inform the theory that we are going to come up with, and I think that for me is very, very important as someone who came into academia from human rights activism, that really being in the field and having what happens on the grassroots inform your research as a human rights scholar is very important.
Professor Babcock, I didn't put this to you, but do you have any thoughts on that?
Yeah, I do. Our research, I think, has no meaning unless it can be absorbed and can contribute to change, right? So what we do and what we've been focusing on more and more, and when I say we, I mean me and my colleagues at the Center on the Death Penalty worldwide, have really been focused on training defense teams and training women themselves who are incarcerated, because lots of times defense teams aren't well educated about gender and don't know much about how to advocate effectively for women. So we're trying also to reach the women themselves, to give them the tools to be effective advocates and to know what questions their lawyers should be asking them. And if their lawyers aren't asking those questions, then that's a problem. And they need to be able to provide certain information to their lawyers and to the courts in order that their experiences are taken into account. So training, I think, and building capacity among people who are direct, rights holders, the women themselves, but also other stakeholders like defense teams and probably ultimately prosecutors and judges as well.
That's great. Thank you. I want to move to storytelling and the arts, and let me know if this is sort of out of your purview, but how effective do you think arts and storytelling and narrative is in terms of transforming legal systems? What impact can they have?
May I go if Samira? Actually, I see the question came from Omid, and Omid, I watched your little very effective and really emotionally impactful film movie that he's made, animation movie on the death penalty in Iran. And I do think arts like that, both in terms of storytelling and art, as you're asking, they do they humanize these cases in a way that do affect the person who's watching it and the general public. So in terms of affecting the public opinion, because they're quite persuasive. And so I think that emotional impact was really, I watched that, and the emotional impact was with me for a few days. And it's definitely, I was going to actually email you to say, is that something that we could use, for example, in teaching? Because I do find that the narrative is so important, both in teaching and in trying again to have that public reach. Because often, like, the dry academia doesn't have that reach, whereas storytelling and arts can bridge the gap between academia and public.
Dr. Harry, do you want to take that on?
This is a little bit beyond the purview of my work, but I can say anecdotally that we've done quite a lot of research in Indonesia, and our main partners there, LBH Mazurayakat, in their office, there is beautiful paintings from those who are incarcerated on death row. And I found that really powerful. Yeah, perhaps that also kind of conveyed notions of hope and the human side of this barbaric punishment.
Professor Babcock, I know you read that letter. It just had a huge impact on everyone right now. But in terms of the arts and narrative and storytelling, what impact do you think that could have?
I think it can have an enormous impact. I think that what artists can convey through song and through poetry and music and storytelling can have so much more resonance because it hits us at an emotional level, right? As Professor Fazeli was explaining, it's something that we can't really convey in words. You know, lawyers, I'm a lawyer, I'm a professor, you know, I work in prose. I try to tell stories, but I'm not an artist. And the legal language can be very dry and can be very distancing. So I think the artist has a unique ability to connect with stories and to relate them in ways that allow us to feel them. And if we don't, you know, if we don't feel these violations, if we can't feel empathy, then we're never going to be able to change the way that people think about the death penalty or about people in prison. So I think art is absolutely vital. And I think that as lawyers and academics, we need to think really hard about how we can do a better job of working with artists to try to, I guess, center them in our advocacy and our struggles.
I think it's important to point out most of these repressive regimes also come after artists who are telling these stories of what these governments are doing. There's a question here from Dave Hedlin, who says, in the Hood and Hoyle book on the death penalty, it was stated that many authorities within retentionist countries marked their move towards abolition by their personal discovery of the prevailing human spirit, that it was at odds with the inhumanity of killing. Is this spirit more evident today than it was in 2009? I'll put that to each of you if you want to take that on. Do you think that there is more of a change happening now than in 2009?
Oh, sorry, Sandra, you go ahead.
You go, Lucy.
I read a really interesting article recently by a scholar who writes on the death penalty called Ron Dudai, who I would recommend people looking up. And he's looking at the abolition of the death penalty and different ways that we categorize the death penalty. and some of the fallacies around that. And I think a really interesting point that he makes, and this is my very abbreviated version of his argument, was that the death penalty as a tool for ordinary crimes is dying out, but the same perhaps cannot be said for the death penalty as a tool for political crimes. And so his paper goes into some of the nuances of that. So I would definitely recommend that as if people are thinking about looking at different kind of trends in abolition.
Thank you. And I will put in the chat the spelling of that Ron Dudai, if anyone wants to look it up. Professor Fazé.
So for me, to be honest, it's very difficult to answer this. I don't know. I know the global trend is towards abolishing the death penalty. However, again, concentrating on Iran is difficult to see that, given that over 900 people were executed in 1 year in Iran for different crimes, but also political reasons as well. So it goes back to the question that Omid had asked around would reason play any part in trying to abolish the death penalty? And unfortunately, I don't think so, because it depends who you're reasoning with. And when you have a hardliner conservative Islamic or Islamist government in place, then that reasoning, I don't see it being there.
Thank you, Professor Babcock.
Yeah, I mean, I'm thinking about the experience of many African countries now, because that is really where we see a lot of movement toward abolition, particularly in sub-Saharan Africa, as I'm speaking about. And, you know, a lot of the countries we're talking about today are retentionist. They have deep roots in the death penalty. It's hard to see how we are going to achieve abolition in the United States in the next 20 years, let alone, you know, I mean, Iran, who knows, Saudi Arabia, a lot of these countries, it's going to really be hard to bring about abolition. But I think our focus on those countries shouldn't obscure that the abolition of the death penalty is one of the great human rights success stories of the last 50 years. You know, when the United Nations, when the UN Charter was adopted, there were only 8 abolitionist countries in the world. And now, you know, it's well over half. And, you know, when we look at the number that still actively execute, it's a handful. You know, it's 20 to 25 countries that carry out executions. And, you know, Africa is still, like Europe and like South America and all of North America, except for the US, is, you know, is largely an abolitionist continent. So I think we're still seeing recognition, and this has been a lot of the trend toward abolition in the last, again, 50 years or so, is that when countries emerge from periods of dictatorship or authoritarian regimes, there is a sense in which abolition of the death penalty comes along with embracing a commitment to human rights norms, a commitment to the progressive realization of human freedom and rights. And I think that is not going to change. I think that will continue to be the case, and we will still see these waves of repression and authoritarianism that we're seeing in so many countries today. But I really do think that the progression toward abolition of the death penalty will continue, even through this, you know, really dark time that we're seeing in the United States right now. There are going to be US states within the United States that abolish the death penalty, and that stop executing, you know, even before they abolish. So that, I think, is important not to lose sight of when we're focusing on, you know, such really dramatic stories of government repression.
Thank you so much. I just want to read a comment that Hussein had made regarding the lawyers and what lawyers can do. There was a question about that. And Hussein is noted here, as Sandra noted, the Iranian Bar Association also exhibits male-dominant tendencies. Both lawyers and judges should undergo gender equality training, as lawyers play a crucial role in reshaping judges' male-dominant views. Furthermore, when interrogators or prosecutors express gender-based biases, lawyers should intervene and ensure that such behavior is addressed with serious consequences. At this point, we don't have any more questions. Do either of you want to make some closing remarks? I will open up the floor to anyone who wants to make closing remarks for this session on women and the abolition of the death penalty.
I think we're all being polite and waiting for the
Yes.
other one to speak.
Could I start with you, Professor Fazayeli? Do you have any closing remarks on this International Women's Day about the subject of women and the death penalty? Perhaps what you would like to, for people who are listening, what you would like for them to take away from this discussion, and then also the larger discussion about women and the death penalty.
Thank you so much, Samira. I have to say this was a place where I learned quite a bit. It's good to hear from other contexts. So to your first remark in sense of what Sandra spoke about in the context of the US and Iran and the comparison, because these are two contexts you don't often compare to each other. And just generally particularly within Iran, kind of the male-dominated judiciary, and also Hussein's comment on how these kind of gender trainings could be effective for lawyers and judges. I don't know how well that would go in a context like Iran, but how important that is kind of the world over. But also since this is International Women's Day, gender equality is at the heart of what we do, and again that's something to kind of ponder about, because really there is no context in the whole world where we can say men and women stand on equal grounds in terms of access and employment and other factors. So for everyone out there, men and women, it is good to think about these basically everything we talked about, but go back to the basis of what we are working on is that gender equality, and hopefully at some point we would achieve it. I like to end on that note of hope. But thank you again for having me today.
Thank you, Professor Babcock. Do you have any closing arguments, Professor?
I just want to say how inspired I am by Iranian human rights activists and scholars who are doing such important work because of the threats that they experience to their safety, not just in Iran, but even when they are doing this work outside of Iran, and how, I feel like in the United States right now, we need to take lessons from activists in repressive states because it's coming our way now. But the kind of pressure that you're working under is something that we've never experienced here. And it's really admirable that you're continuing to do this work in the face of such repression. I keep thinking about that incredible video that went around a while ago. It was actually might have been just an audio of the women in, was it even prison, who were protesting and who were banging. And that video, that sound was just so incredible. And it just gave you this sense of power. These were women, and they were and maybe somebody has the link and can post it, because it was like one of the most powerful things I've ever heard. These incarcerated women who were protesting, I think, against the potential death sentences of some of the women that you've spoken about. So solidarity to you, and hopefully we can all, start to work and connect our struggles.
And I'll make my final closing remarks. So I think that we know that there are far more men on death row worldwide than women. And so the plight of women on death row is often overlooked because they make up a small, however, significant population. And many of their cases, illustrate some of the more, the pervasive gender-based violence and discrimination that women face, throughout society. It's notable that there's a relative dearth of literature on the death penalty in women. And so it's encouraging that there's getting more attention, but, more needs to be done. There's limited data on this. And so I would encourage people who are interested to look more into these women's cases and to try and highlight some more of their stories. And yeah, I think that I'll take from this panel, I will be thinking a lot about the email that you read out, Sandra. So I thank you so much for sharing that with all of us, because those are very inspiring words to take forward from this. So thank you.
Just a note that Bahar Mir Hosseini has put the audio from Evin Prison in the chat if anyone wants to listen to that. And it is also available on YouTube. There was also a video that surfaced a while ago of women singing in Evin Prison. And so that form of joy is also a form of resistance for women inside the prison. I want to thank all of our panelists today for joining us on International Women's Day, and also to all of the people attending and watching online. Thank you so much.
Thank you, Samira.
Thank you.
Bye-bye.